If you want to say it loud, 'cause someone out there listening. If you're gonna think it, think out loud, 'cause you don't know what you're missing till you let them all in. Oh, oh, oh. Tell them what it's all about. Oh, oh, oh.
You're listening to the Divorce Registry podcast, talking about real people, real issues, and real solutions.
I'm Jonathan Fogel, a family law attorney.
And I'm Amanda Johnson, a family law paralegal. This is the Divorce Registry podcast, where we provide informative, entertaining, and invaluable insights into all aspects of family law. You can reach us at thedivorceregistry@gmail.com, and be sure to follow us on Facebook.
Amanda and I are partners at work and in life. We are both divorced, and we have 5 kids between the two of us. Some call it chaos. We just call it family.
We call it chaos too.
Yeah, you're right.
The signs say you'll be coming up roses soon. It all comes back to you. It all comes back to you.
Hey, Amanda, how you doing?
I'm good, Jonathan. How are you today?
I am good. Happy International Day of the Girl.
Oh, yes. I love that. I did see that this morning. On the news.
Every October 11th, we celebrate International Day of the Girl Day, and every year they have a different theme. And today's theme, or this year's theme, is a skilled girl force.
Nice.
And it's all about how to educate and provide girls the proper education and skills they need to enter this growing workforce.
That's great.
Yeah, it's fantastic. So I just wanted to bring that up, and I know you and I both have daughters, and it's an important thing. I sent my daughter a text this morning telling her not only happy International Day of the Girl, but I listed all these things about her to help empower her. And it was interesting as I was going through it, right? I think, and maybe we're getting off topic here a second, but I think
haven't been on a topic.
No,
yet.
but there's so much emphasis, I think, on, oh, you look nice, or you're pretty, or that. And I feel like that's the last thing that should be talked about, right, for young girls. I think there's a message out there that that's the important stuff. Mm-hmm. To me, what makes my daughter, and I think your daughter as well, and girls so special, she is bright, she's compassionate, she's passionate about things, she's learning what's going on in the world, especially right now with all the stuff that's going on in politics. She's paying attention to those things, and she is so interested in learning about what's going on, and I just love that about her, and I wanted her to know that, and I think it's so important. I was watching this morning on the news, and they were talking about all these things that are going on worldwide for this day, and I think it's just a fantastic thing. So
well, now I feel bad. I did not say...
It's a whole day, though. You have the whole day.
Okay, I'll send something. But I agree. I think I'm watching your daughter watch Sarah. She's totally figuring herself out, and more so than I ever thought she would have at this time in her life.
Yeah, it's great. I mean, one of the greatest things about being a father is seeing your kids mature into those young adults and realizing that these certain things are important to them. They may not be important to me, but each kid is so different. They are finding their own way in their own way with guidance from not just me, but from other people, other adults in their lives, and also figuring out for themselves what's important to them. Yeah. And so I'm, enough about bragging about my daughter, but it's a special day, and so I wanted to acknowledge that as well. But what I wanted to talk about today, and we sat down and thought about this. You came to me and said, you know what? If I'm going through a divorce, if I'm somebody who is starting this process or thinking about this process or even in the middle of it, what is the roadmap, right? What are the terminology that is used in this process? How do I get from the beginning to the end of this process?
And not only for those people who are going through it or about to go through it or thinking about going through it, but their extended family. And I can think back, it's probably happened to you many times. It happens to me. And my parents witnessed one of the times it happened where you meet somebody who is in the midst of it and they find out what we do, right? Or that we are divorced, and they just start talking. And their family was there as well, their parents. They start chiming in. They're all so affected by this process.
Sure.
And my parents were very surprised. They're like, oh my God, I can't believe how much is going on, and that they opened up. Like, I go, it's everybody needs to talk about it, and then everybody has their opinions about it,
and their own very unique experience about
Yes.
it. And I think attorneys, and maybe I'll put myself in this category as well, a lot of times we don't do a very good job of explaining to our clients at the beginning of how this is going to go, what kind of roadmap, right? If I'm driving from here to California, right? I use a map or now GPS, but I need to know, okay, what highway am I going to take? Am I going to go from here? Then I got to get on this highway that's going to get me, to California. A lot of times people coming into a divorce process, they don't know how they're going to get from right now to being divorced, what's going to happen. And so we wanted to put together a podcast that gives people that roadmap. Now, granted, there may be detours on this roadmap. There may be road closed signs on this roadmap. There may be U-turns. There's a lot of things. I got a lot of driving analogies. But there may be a lot of that. But what we want to do is try to lay out in a general case, in a general way, kind of a run-of-the-mill type of divorce, what happens from the time you go in to meet with the attorney until you have a signed divorce decree.
Right, and using that driving analogy, if you are a planner like me, I am somebody who, it almost stresses me out to a point that I've tried to back away from being such a planner. But I want to see what's about to happen and plan for it. Like when I'm driving and I'm already moving into the right lane because I know I'm going.
Or you're
why
telling
are you
me,
going already?
Or you're telling me you got to get in the right lane. I'm like, okay, the turn isn't for another 2.5 miles.
I know, but
okay,
you got to plan
thanks.
for that, right?
Yes.
Like I'm going to get in anyway. So that's why we started talking about this. Saying there's people out there. This causes so much anxiety not knowing this roadmap.
Yep.
That if we can kind of take some of that away, then they can focus on what they need to do.
Yeah, and so what we thought is we're going to do a 2-part podcast. So today's podcast, episode 7, is going to be about the divorce process beginning to end if you're going into this and hopefully getting a settlement without ever going to court, right? Episode 8, which will be released soon, is going to be roadmap beginning to end a divorce with more of the traditional litigation type approach.
Where mediation doesn't seem to have worked.
Yeah.
And so we have to kind of plan for moving towards trial.
Perfect.
Right.
Perfect. So let's start with the first thing is having an intake or a consultation with an attorney, right? I mean, that's what it's called, right? And while we're going through this, I want to define some of these terms that people, maybe help them out, right? So the first thing is you have a consultation. I'm not going to get into how you find the attorney or what to ask in the consultation or everything like that, but I want to just lay out the map. Is that all right?
Yeah.
And if you want
I'll
to
jump in when I need to jump in.
As always, please do. But usually a consultation with an attorney is about an hour, right? I mean, usually most attorneys are, 1 hour consultation. Some attorneys, like myself, have a free consultation. Some attorneys charge for their consultation. And what that charge would be, you want to know that up front. You want to know if it's going to be a free consultation or are they going to charge you for it. And during that consultation, you hope that attorney is going to give you a lot of information about what's going to happen. They're going to gather information from you. It's a lot of questions. I know when I'm doing my intakes, it's uncomfortable sometimes for me, right? These people are coming in. I don't know them. They're strangers. They have their own story, sometimes very emotional stories, very difficult things to talk about.
Some are more open than others.
Right. And some will come out and just start literally, throwing up information for me that I can't write down fast enough. Some I have to pull it out of them a little bit, which both are totally fine. And as an attorney, I have to adjust for that to get to what I need to know in order to give them the right advice and information. So that's the first step, is going to some sort of consultation or intake, right? The next step, if you retain that attorney, right, there's a retainer that is signed. So retainer can be used in 2 different ways, right? There's a retainer of an attorney, right? You retain that attorney to work for you. The second thing is signing a retainer agreement. Attorneys are required to have you sign a retainer agreement, so there's a contractual obligation for them to do the work for you, and then, of course, for you to pay them to do the work, right? Then there's also a retainer payment that you make. Most attorneys will require that in order to retain their services, that you pay an upfront retainer fee. That's in almost all cases is used to put into an account that's called an interest on lawyers trust account. An acronym is IOLTA account, which is essentially a trust account because attorneys have to hold that money in trust for their clients. We can't take the money until we've earned the money. So we take that retainer, put it into an account. As we bill on the case, then the client is charged for that, and then we use that retainer to pay the bill.
Which I will just jump in really quick and say one thing we've moved towards in our firm is sending bills out to the clients, every 2 weeks?
Every 2 weeks.
We've learned that family law is a very different, fast-moving beast than many other practices of law. And within 1 week, your bill can shoot up because there's lots of correspondence going back and forth between attorneys or
you're drafting
things, just whatever it may be. And we want that client to be very aware. We don't want them at the end to go, wait, what? I didn't know that you were doing all this, even though they did see everything we were doing, but it's not the time in their life that they're very going to be that aware of it.
Yeah, and maybe this is a really good time to bring this up, is as the client, your attorney is working for you. You have to remember that, right? It's not the client that's working for me. I'm working for them. And so as part of that, as the client, you should have an expectation that your attorney is providing you with information about what they're doing. And so that idea of giving them a bill every couple weeks instead of once a month or every other month or whatever is helpful so the client can come along with that and see, okay, this is what I'm being charged for. And then they can, maybe if they have a question, they can call then, or if they think, oh my God, this is getting real expensive, there has to be that dialogue between you as the client and your attorney that's representing you.
Right.
All right. So there's what I wrote down is there's three ways to be charged for the divorce. One is a hourly rate, which is, I think, probably in 95% of the cases, you're going to be paying your attorney hourly. The hourly rate depends on a lot of different things. Depends on where you're located in the country. Attorneys in places like New York, LA, Chicago usually charge a higher rate than attorneys in Dubuque, Iowa, right? I mean, it's just the way things are. There's also, it depends on the experience the attorney has. Usually the longer they've been practicing, the higher they're going to charge. Their rates are going to be a little bit higher. Those are things you want to know, though, up front, and they'll be laid out in the retainer agreement that you're going to look at and sign. So most of the time, it's an hourly fee, right?
And not just the attorney's rate, but everybody else on staff that will be touching that file, the paralegal, the associate, the legal assistant, everybody else, their fees should be listed on there as well.
Absolutely. And that retainer, that's what should be in the retainer agreement. Mm-hmm. The retainer agreement should say what is you're hiring the attorney for, whether it's a divorce, whether it's child support modification, whether it's paternity, should lay that out, what's covered. And also really have all the names of the people in the department and what their hourly rates are and how they're going to be charged. Mm-hmm. Another way that you can be charged is a flat fee. Now, some attorneys in family law charge a flat fee for certain things. It depends on the type of case that's going on, depends on the attorney, but that is another way to be charged, a flat rate. That way you know up front, here's the most I'm going to pay. Most family law attorneys don't do that because family law cases, like you said, Amanda, can turn sideways really quick. It's really hard for us to gauge what it may cost for a flat fee. And then the third thing I want to point out is that family law cases, attorneys are not allowed to take family law cases on a contingency fee. So like personal injury cases, you can take them on a contingency fee, which means at the end of the case, what that person is awarded, the attorney gets a certain percentage of that. Family law attorneys are not allowed to do that.
Yeah, that would be bad.
So if you have a family law attorney out there that's saying, I'll take a percentage of your property award, don't hire that attorney. They're violating the law, or they're violating the rules of professional responsibility when it comes to taking on cases. The next thing that happens is the attorney should give you a questionnaire to fill out, right? You want to talk about the questionnaire since that's a lot of what you deal with.
Yeah, I was going to say that's something that comes straight to the paralegal usually, or the legal assistant. It's a questionnaire with all of your personal information that we need in order to start your process. And I'll say, so usually we have you fill it out in order to draft the summons and petition for dissolution of marriage, which we will talk about. Even if we're not going to be drafting those documents right away, sometimes the choice is made in the case where we're not going to do that right away. We've decided, the client said, I'd much rather have a letter go to my spouse letting them know that we're going to start this process and we just want to start talking first about, however. That doesn't mean we don't need the information. We need all of your information. It saves you money. We don't have to reach out to you and ask for it and bill you for doing that. It's all of your personal information, social security number, birth dates, marriage date, asset and liabilities information, a complete listing of what you have together. And sometimes you don't know what the other spouse, that's okay.
Yep.
And it's okay to even say that. Like, I appreciate that. And they say, so-and-so may have other bank accounts. I don't know. Great. I'll put that on the spreadsheet and I'll put a question mark, which helps me.
Yep. And so it's really important that when you get that questionnaire that you work with your attorney to fill that out, or work with the paralegal, fill that out. If there's documents that are being requested, make sure to get those documents. If you don't have them, just let the attorney know that, because part of what we can do is we would then request that from either the other attorney or opposing party to get that information. We have ways to do that. We'll talk about that down the road when we talk about discovery. So once we have that questionnaire, the next thing that's done is drafting of the initial pleadings. Now, pleadings is another term that people are like, I don't know what that is. Pleadings are simply something that is provided to the court. I mean, that's the best way to describe it. A pleading is something that gets filed with the court. It's a document that's filled out. It can be a lot. There's a lot of different types, and I won't go into all of those. But for lack of better term, pleading is what we use. The best way to think about it is this is a document that the judge is going to look at.
And it contains the case caption for your case,
Right.
which has your name, your spouse's name, the case number, the court file number.
Should turn off my phone next time.
Nice.
Yeah.
The county that it's in. And so that is contained on all of those pleadings.
Right. And so the initial pleadings that are filed are called a summons and petition for divorce. So that all that means is the person that is starting the divorce action is called the petitioner, because they are petitioning the court. In other words, they are asking the court for a divorce, because we have to remember, in order to get a divorce, you have to go to court and have a judge sign something. So you're petitioning the court, asking the judge to sign a divorce decree. The person that is served with the summons and petition is answering that. They are the respondent, because they are responding to the request. So those terms are petitioner and respondent. That's how people are identified in a divorce process. The summons and petition is drafted by the attorneys on behalf of the person that's asking for the divorce. Then the person receiving those has to draft what's called an answer and a counter petition. And you want to talk about what's in those things briefly? We can.
Well, very general requests
I'm
for
going
the
to turn
court.
off my phone while you're doing that.
Very general requests for the court are in those documents. You're asking, if you have children, you're asking for whether you want sole legal, sole physical custody. If you are asking, if you're asking for the homestead, you're asking for that.
Support,
or child support, or spousal maintenance. All of those very general requests that we can move off of.
Yeah, you can change your mind. The petition, I'd say, is kind of the initial ask, right? That's what I would say. And the answer is the initial response to that ask. It doesn't mean that that's where everybody is going to go later on, but that is what needs to be in those initial pleadings, those initial documents.
And again, just going off of the roadmap, off of, a detour, you don't have to start a case with these things. Again, you have to talk with your attorney about what's best for your case, and if you should be filing these, if you shouldn't, if you should just be sending a letter, whatever works. There are I cannot stress it enough that we want to work with the client in a way that is best for their family to move forward.
Absolutely. And today is more just about this is the roadmap in a traditional type of case. Yes. There are definite exceptions to these things. Yes. And if you want to, I guess what I would say too, if you have questions about these things, you can always send us an email to the Divorce Registry Podcast at gmail.com. If you have questions about the process or think, well, in my case, this may be different, we're happy to answer those questions separately. Sure. The next thing, once those get filed, is that there would be what's called discovery. And discovery is just a fancy term for, hey, I'm going to ask you for a bunch of stuff and you got to give it to me, right? So in this case, we're talking about the informal type of discovery. There's formal discovery, which we're going to talk on episode 8, more about that. Informal discovery is essentially a letter that your attorney would send to the other attorney or to your soon-to-be ex saying, hey, in order for us to put together this asset and liability spreadsheet, in order for us to figure out how we're going to divide things, we need some information. We need things like paychecks for income. We need most recent statements for your retirement accounts, for your bank accounts, for your credit cards. We need titles to vehicles. We need information about the mortgage and a legal description. There's those kind of things you're asking for. And then there's an informal exchange of that information.
That's the key term, informal, right? Yeah. At this point, because we haven't been in court, we haven't set that yet, then it's informal discovery. You're not forced. Nobody's forced to actually produce anything at that point, but you're hoping that you can work together.
The idea is you're working together,
yes.
right? The idea is you're cooperating with the other party or with the other attorney to try to come to some agreement. Mm-hmm. And one of the things also that's usually asked is a budget, especially if there's going to be a claim for spousal maintenance or alimony. It starts with the budget. And so getting that information not only from the other side, but also as you getting it to your attorney, what they're asking for is really helpful.
Well, in the budget, it's something that comes up every time we're drafting the final divorce decree, which is a stipulated judgment and decree if it's been agreed upon, is we need a budget number in there. Mm-hmm. Those require it. And I think sometimes, unless there's somebody's asking for spousal maintenance, that gets pushed to the back burner.
Right.
Again, this goes back to filling out your questionnaire fully and just doing it. And it does take time and it is a pain and it's not something you want to do because you're not doing anything you want to be doing right now by getting divorced. So
no,
it's
certainly not.
But it will help you in the end and it helps us.
Yes. All right. So the next thing that happens after there's an exchange of that assuming that everyone plays nice in the sandbox and exchanges all their information, right? That's
Correct.
What we're talking about.
Yes.
Is the next thing there might be, in Minnesota, we call it an initial case management conference. Other states may have similar type of process. Essentially what that means, that's a fancy term for saying, hey, we're all going to go meet with the judge and let the judge know what we're doing. And the judge is going to say, okay, well, how are we going to resolve this? Do you guys have any agreements? Do you not have agreements? And what is going to be the alternative dispute resolution process that we're going to pick? So attorneys throw these terms around like ADR. That means all the ADR means is it's an alternative dispute resolution process. And a better explanation of that is simply, how are we going to avoid going to court? What alternatives to going to court are we going to use? And that could be mediation, it could be arbitration, it can be a lot of different things. It can be informal meetings, but that would be the next step in the process, is going in front of that judge. And the whole idea of these initial case management conferences is that the parties, and I use the word party, those are the people that are going through divorce, right, would go in front of the judge. It's very informal. The judges don't make decisions unless there's agreements. Mm-hmm. But it's really a time for people to understand this is the person that's going to help us if we can't reach an agreement. It's also a chance for them to see the courtroom and maybe even make them feel super uncomfortable to think, if I don't have an agreement, I'm going to be sitting here and this judge is going to have to decide these things, which is terrifying.
Right, because there are times that even we have asked and agreed with opposing counsel or to move the ICMC date, right? To not have it because we already have a mediation set. We're like, hey, we're going to be going to mediation, so we don't need this. Can we get? And we get out of it. And I started saying, I think everybody should have to show up.
Sure.
I think
and
what you just
a
said,
lot of judges won't move it because they feel that there's a big benefit to it as well.
Yeah.
To have them look the parties in the eye and have those people have to look at the judge. And a lot of times the judges will even come down from the bench and sit down with us and make it real informal. And it's helpful for those people to see, oh, this is what's going to happen if we don't agree. And the judge can kind of give them that, I don't want to call it a pep talk. It's more of a warning, almost like, look, if you don't agree, I have to decide these things, and I don't want to. Every judge that I've ever spoken to has said they don't want to make decisions about people's kids, about their money, about the rest of their life. They would rather have people do that themselves. Now, they'll do it if they have to, and they will do the absolute best job that they can, but they don't want to make those decisions, right? I've had judges, basically say to parties, if you leave it up for me, if you leave this decision up to me, I'm going to screw it up. Not because they don't know what they're doing, but because no matter what they do, they're never going to know your kids as well as you do.
Right.
They're never going to know your financial situation as well as you do. And someone's going to be unhappy, right? So that's the initial case management. After that, we talked a little bit about the alternative dispute resolution process. In Minnesota, and I think in most states, it is mandatory that you go to mediation before you have any sort of trial or anything before the court as far as making a decision. And I think that's fantastic. What it's essentially saying is you need to go and try to figure this out yourself. You go to mediation for that. Now, there are exceptions if there's domestic abuse. They don't require you to go to mediation. But again, we're talking about more of the...
And that doesn't mean just exchanging settlement like letters back and forth, right? That doesn't count as settlement efforts in a sense of ADR, as alternative dispute resolution.
It does not. Now, the way I approach it is the minute someone comes in, I'm like, hey, let's start focusing on settlement. Let's see what we can do to try to get a letter out or make some sort of proposal. That can all be done in the background, no question, right? Throughout any of this process, let's make it clear. This case you can get off this train at any time if you settle, right? And your attorney should always have that focus on how can we settle? How can we stop this from going any further, right? Your attorney should always have that focus. But this ADR, this alternative dispute resolution, is a formal process. You hire a mediator. The parties pay for that mediator. It's a third person. It's a neutral third person that meets with the parties, meets with the attorneys, sometimes in the same room, sometimes in separate rooms. Sometimes they go back and forth in an effort to try to come to a full resolution. Sometimes mediations result in a final and full complete settlement. Sometimes they settle on part of the issues, but not all of the issues. And in Minnesota, there's traditional mediation. And then there's also in Minnesota, they started these called social early neutral evaluations and financial early neutral evaluations, which are a more evaluative type of process where you go in and meet with experts that have more experience and they evaluate the case and say, hey, look, in this 3 hours that we've met, because mediation is usually about a 3-hour process each time, they say, well, look, given what we know, given our experience, given what we know about the judge, given what we hear about your case, here's where we think this is going to end up going. So this is our recommendation, or this is our evaluative opinion. And then you hope that your clients or the two clients can sit down and say, well, geez, if that's really where we think it's going to go, why spend all this extra money to get the same results?
Well, and now in mediation, that's one time and place where you have actually really been heard. You get to speak up as the client and say, and so you know that person's giving you an evaluative opinion based on what they have heard from you. We can't tell you that that's going to happen in court.
Of course not.
Not the same way.
Right, because there may be totally different evidence that comes up in court, or a
Right.
judge is going to look at it totally differently. But it's an opportunity to reach that settlement and keep that control to yourselves. So assuming that you do reach an agreement in mediation, the next thing that happens is one of the attorneys or both of the attorneys would prepare something that's called a stipulated judgment and decree. So a judgment and decree is simply what people think of when they say, oh, my divorce decree, right? What the terms are. It is a legally binding contract that is signed by the two people getting divorced. If they have attorneys, it's signed by the attorneys, and then it's ultimately submitted to the judge for approval.
Right.
So the judgment decree has two parts, I always say. It's got findings, which is basically a fancier term for what are the facts of this case? What is everybody's names, dates of birth, how old are the kids, what assets do they have? So what property do they have? Do they have a house? Do they have cars? Do they have retirement? Those are all listed in the findings. That's the first part of the stipulated judgment decree. And then the second part is what's called the conclusions of law, which is basically a fancy term to say, well, how are we going to divide all this stuff? What are we going to do about the kids? And that part is somewhat repetitive of the first part because it basically goes through and lists all the assets again. But it basically says, well, mom's going to get this, dad's going to get this, this is what we're going to do for custody, this is what we're going to do for child support. And it has the specific order that people need to follow. Right. And if you do it this first way that we talked about here on episode 7, you get to decide what's in there. You get to draft that. You get to be the master of what ends up being in your final agreement.
Yeah, and I think that when you are, I've stuffed mine away, and I don't think I've ever looked at it again. I think
Right.
because we came to and so we modify it between the two of us all the time now without even looking back at what it's supposed to be. It's not.
Yeah.
And
And look, it evolves over time, and you hope that you don't have to ever go back and look at it again. That would be the ideal. In episode 8, we'll talk about things that happen when people
that
have to
doesn't
look at
happen.
it. And the last thing I'll mention is that there are follow-up items after your decree is entered. So, for example, if you own a house and someone's being awarded the house, you may have to do what's called a quitclaim deed, which transfers the title to that house to the other person. Someone may have to refinance the mortgage. There may be a transfer of retirement accounts. So we have to do what's called a qualified domestic relations order. An acronym for that is QUADRO, which means that that's a way to transfer retirement from one person to the other without taxes or penalties. So there are some follow-up things that need to be done. And in this first track that we talked about today, those things are all done with the cooperation of the people going through it, with the help of their attorneys, without ever having to have a judge make a decision.
right.
Which the reason we talked about this method first is that this by far is the preferred method.
The only thing the judge has to do on this is review and sign off on what you guys have agreed to.
And I will say that in cases, at least in Minnesota, if you both have attorneys and you have a signed agreement, you never have to go to court. All you have to do is submit that to the judge and they sign it. Now, if one person's unrepresented and there's kids, you have to go and the judge basically just has to ask you the right questions. You have to say, yes, you agree to everything, and then it's signed.
Right.
But that by far is the best process. It's what I always try to aim for. And if we can do that, everybody, I think, comes out of this much better.
That's the majority of what we see too. It really is. I mean, it's a painful road to get there sometimes, but we do end up settling a lot of cases.
Absolutely.
Yeah.
And sometimes maybe a little longer than others,
Yeah.
but that's always the goal.
Yeah.
So we got through this timeline.
Yeah.
All right. Thank you guys so much for listening. We appreciate it. And if you have any questions, send it to the Divorce Registry Podcast at gmail.com.
The information in this podcast was for general purposes only. The information provided was not legal advice or a legal opinion. You should seek the advice of legal counsel of your own choice before acting upon any information from this podcast. Contacting us by phone or any other means does not establish an attorney-client relationship.